Good evening and welcome, everyone. Hopefully, you can understand me okay. This cold is no joke. I'm Rosemary Picarelli. I joined AFT Connecticut this past summer as the new communications associate. Usually, our professional development coordinator, Jennifer Benevento, hosts these PD webinars, but I am filling in for her as she's currently on maternity leave. I also want you all to know that this webinar is being recorded. It's our hope that we'll email a link of the video to all that registered in the upcoming weeks. I'm going to post the link in the chat, which I just did, which asks for feedback. It's a feedback survey. If you all could please click on that at the end of the webinar, we would be greatly appreciative. That's how we learn what our members are looking for in professional development opportunities. I will remind you again at the end. So I'd like to welcome Eric Chester, and I don't see James. Is James coming?
No, just me.
Chester, well, you are all we need. Who will be presenting today's webinar, Legal Issues for Healthcare Staff. Eric is AFT Connecticut's attorney with Ferguson, Chester, and Doyle. Before I give the floor over to our presenter, I would like to snap a quick screenshot, which I'm going to hide from. Okay, so now I'm going to hand it off to Eric, and you can take it away.
Thank you, Rosemary. Am I the host? Can I share my screen?
You are the host.
Okay, great. Thank you. Well, thanks for being here, everybody. I see some familiar faces and names. I see Dale here, and it's good to be with the rest of you. I know it's not an easy time of the year between the holidays, and I know it's not an easy time for any of you, given with what you're facing with the resurgence. What is the third or fourth resurgence of the virus now? And I'll just say that, you know, what you're all doing is a Herculean, a heroic effort, you know, in trying to keep people alive, trying to keep people safe. I hope you're keeping yourselves safe, keeping one another safe, you and your colleagues. You know, I think, as most of you know, the union is there as a mechanism to support you, whether it's a health and safety issue, whether it's lobbying for legislation, trying to procure resources for you, you know, or just working with the employer to ensure proper measures are put in place to ensure your health and safety. You know, your union is certainly a key player in that regard. Again, my name is Eric Chester. Our office provides a number of legal services, both to the state federation and to locals and to members of the locals. And one of the things we do is we provide some educational training like we're doing tonight. I'm going to go over kind of two big picture topics with you this evening. One is mandatory vaccinations, mandatory testing, and exemptions, and what that looks like. And then the other is workers' compensation, which does relate to COVID. We've had some COVID cases. We've had a number of COVID cases in healthcare. And so whether or not you hurt your back at work lifting a patient, or you contract COVID at work, the process is relatively the same. So I'll go over those two topics. I have a PowerPoint presentation that I'll run through. My plan is to leave time at the end to answer your questions. If you have questions related to the topics, great. And if you have questions that might be outside those two topics, by all means, please raise them. And if I can't answer them, I will. And if I can't, I'll look into getting you the answer. I'll share the presentation with Rosemary at the end, and then she can share that with Sherry and John to be disseminated out. Okay, so let me bring up my screen. Okay, can everybody see that okay? Okay. So again, I'll be talking about some legal issues for healthcare workers, again, primarily testing, mandatory vaccination policies, and workers' compensation, which does relate to potentially contracting COVID at work and or getting hurt at work. A lot of you know the answer to this question already. You're living it every day, but can an employer institute mandated vaccination policy? The short answer is yes, they can. The EEOC, the Equal Employment Opportunity Commission, that is the agency that governs and hears cases related to employment discrimination, has ruled definitively on it, that yes, an employer can can create a vaccination policy that requires vaccinations. There are two things an employer must allow for. One is religious accommodations, and the other are disability-based accommodations. Those two things have to be part of any mandatory vaccination policy. And I'll talk about each one. The first is the disability-related accommodation, or what is also commonly referred to as a medical exemption. I'll say at the outset that I haven't seen any, maybe some of you have, but I have not seen any medical reports from any treating physician stating that someone is medically unable to get the vaccine. That may exist, doesn't mean it doesn't. It just means that I haven't seen one. And we represent a lot of healthcare workers, and none of them have come across our desk. But in any event, these accommodations, these exemptions would apply to not just a mandatory vaccination policy, but they would apply to anyone who would need a disability, who would need an accommodation due to a disability at work. So it's good information to have even post-pandemic whenever we get there. So this type of accommodation due to a disability is governed by the Americans with Disabilities Act, or commonly referred to as the ADA. And the ADA requires that a reasonable accommodation needs to be offered or proffered unless the employer can demonstrate that that accommodation would present an undue hardship to the employer. In other words, it would just be too difficult for them to do. And one of the factors in determining whether or not an accommodation would present or demonstrate an undue hardship is cost. It's not the only factor, but it is one of the factors. The other thing that's relative to COVID specifically is that an employer may have what's called a qualification standard, which means that you would have to show that the individual would not pose a direct threat to the health or safety of individuals in the workplace, even with that accommodation. So you can imagine that someone that's not vaccinated, that could certainly be posed as an undue hardship on certain types of employers, specifically healthcare workers. Someone who is unvaccinated could present, really not arguably, but would present a direct threat to the health and safety of not just the patients, but your colleagues, your coworkers. Under the safety-based qualification, would the employee pose a direct threat due to a significant risk of substantial harm to the health and safety of the individual, that's the person working there, or others that cannot be eliminated or reduced by a reasonable accommodation? And there's a balancing test that's used. Is it, does the undue hardship or the significant risk outweigh the need for the employee to have the accommodation? And I know in my conversation with some local leaders, as well as John and Sherry, that not every healthcare employer, not every hospital applies this the same. Each hospital does have to apply their policy uniformly to everyone, but that doesn't mean that Danbury Hospital has to have the same policy as Bacchus. Employers are allowed latitude in coming up with those policies. And I know that there are some hospitals that are allowing exemptions from the vaccine and affording accommodations that might take that worker outside of direct patient contact. I know there are other hospitals that have said no, that having an unvaccinated healthcare worker just stepping into the hospital poses a risk that outweighs the requested for accommodation. So again, certainly any hospital can't pick and choose how it's going to apply this balancing test. They have to apply it uniformly, but some hospitals may have different policies than others. Again, this applies not just to COVID or not just to a vaccination policy, but this applies to any disability accommodation or an accommodation due to a disability. When an employee is seeking a disability accommodation, the employer may talk with the doctor to fill out documentation to support the request for the accommodation. That can and does happen. The employer can ask you to submit to an IME, an independent medical exam, to see if a second opinion might come out differently. They are allowed to do that. And they can and should, quite frankly, engage with you and your doctor to have discussions as to how can we meet these potential accommodations. If a doctor, your treater, suggests that you need a certain accommodation, the employer says, well, we can't do this, but we could do that. They can go back to the doctor and say, hey, look, we read your report. We understand what you're suggesting. That is something we're not able to do, but you think we could do this? Would this, afford your patient and our employee a reasonable accommodation? And those discussions, are a good thing. And that's the process an employer should be following every time there's a request made for a medical and/or disability-related accommodation. Again, vaccine or otherwise. Any questions on a request for disability accommodation / medical accommodation before I move on to the next one? Okay, seeing none. The next one is the one that's more commonly used, is the religious exemption. Again, like I said, I haven't seen any medical reports suggesting that someone is not able to get the vaccine due to a medical reason. However, we have seen a number of these. These are the religious exemptions. This isn't covered by the ADA. This is covered by Title VII of the Civil Rights Act. And that prohibits discrimination against an employee's sincerely held religious belief. Same thing as a disability requested accommodation. The employer must provide a reasonable accommodation unless it poses an undue hardship. Again, it's a balancing test. Can we do it? Is it a reasonable request? Can the employee still do his or her job with the requested accommodation? And can the hospital, can they make it happen? Deeply held religious beliefs are given broad discretion. We've gotten some questions. Is this a real religion? Is this really legit? I will say that the EEOC and the CHRO, the same agencies that govern disability discrimination cases, also hear these types of cases, and they give sincerely held religious beliefs broad discretion. They're not interested in defining or putting brackets around what's a real religion and what's not. So more often than not, they're going to lean towards acknowledging the fact that a person does have a sincerely held religious belief. And, if no reasonable accommodation is possible, again, if that's real, the employer can exclude the employee from the workplace. Say, look, we can't accommodate you. It's an unreasonable request. We have to keep you from the hospital. We have to keep you out of the workplace. But they should still make an attempt, a good faith effort, to try to accommodate that employee, again, as long as it doesn't present an undue burden. And the slide here references, remote work. Obviously, 90% of our healthcare workers couldn't really do their job remotely. It wouldn't be an option for the vast majority of our members. But nevertheless, the employer is, while they're not legally obligated to provide every requested for accommodation, what they are legally obligated to do is to go through the process, to make an effort, to meet with the employee, hear from him or her, figure out what the requested for accommodation is, and see if they can do it. That what they cannot do is send out an email saying, don't bother applying for accommodations, we're not granting any. That would be a violation of the law. They cannot do that. They have to hear each person, weigh the merits of their request, and then go through the process, see if an accommodation can be made. If any of our members feel as though that they're being discriminated against because of a disability, a failure to accommodate due to your disability, or you're not being accommodated due to your sincerely held religious beliefs, the recourse is filing a complaint with the CHRO, the Connecticut Commission on Human Rights, or the federal sister agency, the EEOC. We typically do not get involved in those types of cases. Those are individual cases. They're not collective cases. It's not a case that the union would bring on an individual's behalf. However, we have helped a number of members kind of facilitate through that process, point them in the right direction, get them the right forms, even assist them with filling out the complaints. But we typically don't provide legal representation on these types of cases. And I will say for the union leaders on the call, same thing. You know, a disability accommodation or religious accommodation is outside of collective bargaining. We know that unions do a lot of things that are outside of collective bargaining, right? We're in the business of helping our members every chance we can. And I would just say the same thing here, that, you know, if a member is requesting an accommodation and there's a meeting with HR to discuss that requested for accommodation, the member wants the union steward there, the union steward should go, you know, and be a support person if they can be there. And but at the end of the day, it may not be a union grievance if the requested for accommodation isn't provided. The recourse, you know, would more appropriately be before the CHRO. Okay. Okay. So there are these new mandates that have been recently passed, however, not yet implemented. I'll talk a little bit about that. But just a couple of months ago this year, the president issued a federal executive order, which outlined that employees working for large private employers, which many of you fall into this category, those working for the federal government, federal contracts, and healthcare entities, must be vaccinated against COVID. And the executive order directed OSHA to come up with rules, regulations, and guidance as to how to enforce it, how to monitor compliance. So that did happen, as most of you are, I'm sure, familiar with. And what the federal vaccine mandate covers, again, it's all covered employees, which I think encapsulates most of you, ensures that the employees are fully vaccinated with either 2 doses of Pfizer or Moderna, or the 1 dose of the J&J vaccine, and that has to happen by January 4th. Those employees who are not fully vaccinated produce a verified negative test to their employer on a weekly basis. And they must be removed from the workplace anytime an employee receives a positive test or is diagnosed with COVID by a healthcare provider. I know Sharon and I were talking a few moments ago that there are some nuances to that as to whether or not, if you're vaccinated and you test positive, and whether or not you're symptomatic or asymptomatic, it may differ. But for those who are unvaccinated, they're providing the weekly testing, providing a negative weekly test, and if it's positive, they're going to be removed from the workplace. The federal mandate also states that all covered employers, again, these are your hospitals, are required to provide paid time off for employees to get the vaccination, and if needed, sick time to recover from the side effects if you have to miss work as a result of getting the vaccine. All covered employees must ensure that unvaccinated employees wear face masks. I'm sure all of you are wearing them regardless of vaccination status, but that's in the federal mandate as well. And the testing requirements for unvaccinated, that begins on or after January 4th. Now, some of the preliminary rules that have been promulgated by OSHA and by CMS, that CMS is the, I always forget the acronym, but it's the one that governs Medicare and Medicaid services, which kind of gets the federal government the ability to enforce these regulations and these mandates. Again, it requires that employees for these covered employers receive their 2 doses or 1 dose if it's the Johnson & Johnson. Those who are unvaccinated, again, produce the weekly negative test. That's supposed to have started December 4th. And again, those employers are required to provide paid time off to get the vaccination or sick time to recover from the side effects of the vaccine. And again, these mandations all allow for the religious or the disability-based exemptions that I was just talking about a few moments ago. So those, even though it's a federal mandate, and again, we'll talk about implementation in a few moments, but even though it's a federal mandate, they're still required to go through those processes that I was talking about, and engaging employees who are looking for either a religious or disability-based exemption. Now, as you probably a lot of you saw in the news, these mandations were challenged in court, in federal court, and they were stayed, they were delayed. The courts imposed an injunction on their enforcement, which means that, again, implementation is on hold on these mandates. This case is going to be heard before the United States Supreme Court, January 7th, I believe it is, be oral argument. Briefs have been submitted on the issue. Again, the attorneys will argue the case. I would encourage any of you who aren't working and aren't exhausted after working, you can hear these oral arguments online for free. It's pretty interesting. Maybe only for me and others like me, but it is interesting to hear people argue about things that concern you directly. So you can hear that oral argument on January 7th. So again, the CMS and OSHA have announced that they're going to delay enforcement of these mandates until the case is heard and the case is decided. If it's argued January 7th, I mean, we should have a decision. I think the Supreme Court would move on this quickly. Maybe February, March, we'd have a decision, maybe sooner. Of course, we have our own mandates here in the state of Connecticut. Governor Lamont issued Executive Order 13A. Department of Public Health requires that all unvaccinated nursing home staff receive weekly testing for COVID-19. I'm sure that has already begun happening. Executive Order 13B, September 7th, all employees working at long-term care facilities must be fully vaccinated, must have received their first dose and either received their second dose or have an appointment for it, or must have been exempted from vaccination for religious or disability-based reasons. Again, those exemptions and the process for applying for one all remain effective regardless of whether or not you're in the federal mandate or operating under Lamont's executive orders. Those processes are all there. Okay. I'm sorry, I think there's the same one twice. I apologize for that. Okay, so for the unions, these are mandations. They're going to happen. Again, we'll see what the U.S. Supreme Court does with it. But assuming the court falls on the side of medicine and science, these mandation policies or some form of them should be implemented shortly. What, if anything, can the unions do in response to this? I understand, you're going to have members who aren't going to be pleased with being told they have to get a vaccine. And to the extent that union leaders are faced with that frustration, there are some things the unions can do. One thing you can do is you can demand to bargain the impact of these. I mean, these are arguably changes to the workplace, changes to your working conditions, and you can seek to bargain over some of these and reach agreements on them. And these are just some examples. How are we going to schedule the vaccinations? Who's going to go when? How are we going to cover shifts when people are off work getting vaccinated? How are we going to deal with the time spent participating in the vaccination? How is it going to be paid? Sick leave if you aren't feeling well after the first, second, or even the booster shot. You may want to negotiate, again, process for getting your members the booster shot. How's that going to work? And then you could also bargain for the process if you chose to, if the union chose to. You can bargain for the process of applying for these exemptions, how that would work. And that might be a good thing too. Get the process set to paper. Here's how it's going to work. You submit your applications for exemptions to this person. Within 10 days, they're going to have a meeting with HR. Within 10 days, they're going to have a decision. you know, and maybe some kind of appeal process. You could certainly bargain over that. Okay, before I move on to kind of the second topic for this evening, any questions on anything I've gone over so far on vaccination, exemptions, those types of things?
I do. I have a question.
Sure.
Our bargaining didn't go so great. We got hung up on pretty much, never got anywhere really. The question is when sick time to recover from the side effects of the vaccine, if they say the employer is responsible, that comes out of our own sick bank, or, I mean, they wouldn't bargain anything really well when we tried to ask all those questions. So that's my question. If the federal government is mandating they take care of our sick time, does it have to come out of our own sick bank?
That would be something that you would hopefully be able to negotiate, Dale, whether, you know, how to deal
Well,
with it.
that wasn't any success.
Yeah.
Okay.
Uh,
But nobody should be penalized. Is that a grievable situation if someone is written up for using the sick time for that?
Most
Purpose.
likely, I would say most likely it wouldn't be. If you're sick, you call out sick, you would use sick time.
Yeah.
If you get your second shot and you're not feeling well, absent an MOA that you were able to negotiate with the employer, you know, if there's nothing on that and you're just feeling sick, regardless of the reason, whether it's, you know, a cold, the flu, or your second shot, you may have to use sick time for that.
Can I ask, did the emergency, the OSHA Emergency Act, did that expire on the 23rd or 25th or whatever? When is it set to expire again? Because in that, it said that they had to give you 8 hours per shot of time, not your own PTO.
I'll look and see what the expiration is. That's a good question, Sherry.
I know it was December 20th something. I'm just
Okay.
not sure which, but I was hoping they were going to extend it because Hartford Healthcare specifically told us that they were giving us the 8 hours for vaccine reaction because of the OSHA emergency care, and that I'm afraid if that goes away, then our 8 hours is going away too.
I imagine it would. Yeah.
But if that's
Yeah.
something that OSHA said that it was like, you know, a regulation, then L&M should be getting it too, at least 8 hours, because that's a regulation set by OSHA.
I'll see when
Okay.
the expiration date is, Sherry. It's a great question. But if that does expire, and it's a great benefit, you know, to get 8 hours of PTO without being charged against your sick time for each shot, that's only fair, right?
Yeah, if you have a
should be
copy
there.
of that regulation, send it to me.
Okay.
Yeah, thanks.
All right, let me go back to okay. The second kind of topic I'll be talking about is something that we're seeing a lot of, especially given, you know, how short-staffed some of you are, and we know that when there's a staffing shortage, workplace injuries are on the rise. You guys are working longer, you're tired, and that's when injuries happen. And we're seeing more and more injuries among our members in healthcare than we have in a long time. A couple, just 3 takeaways, and I'll go over this during the course of the slides, but one, always report an injury to the employer. Again, you suffer a severe injury, you know, you can't fill out the paperwork right then and there. That's fine. That's always going to be fine. But certainly report it as soon as you're able to. Ideally, you want to report it as close to the event as possible. But again, with the understanding that if it's a really severe injury, and you have to seek immediate medical attention, you may not be able to fill out the report right away. That'll be fine. Seek medical attention right away. Again, that's always the case. And then make sure you file what's called a Form 30C. And again, you have 1 year to file a workers' compensation claim from the date of injury, or in the case of transmission of COVID, you catch COVID, you think it was at work, you have a year from the time you attributed it to the workplace. So that could be the date of the diagnosis, the date that you say, wait a minute, I was working that day. I think I was exposed to COVID patients. I think I got it at work. The clock starts ticking then. However, you certainly don't want to wait that long to file your claim. You want to file it earlier rather than later. So this is what a 30C looks like. It's available online. I would advise every union steward to have a stack of these, or at least, have the link readily accessible to share with members so that they can get to it and fill it out. You can fill this out online. It's not a really detailed report. It's pretty straightforward. The things, obviously you list your own information, you list where you work, and then under injury, it just asks you some very basic questions about, the injury. And the bar is not very high as to how detailed you have to be on these. It isn't. They just want to know how you got hurt, what day. That's it. And that it happened while you were working. So in the event you think you got COVID at work, you had an exposure, you would just put exposed to COVID patient on 12/27/21, diagnosed with COVID on 1/2/22. That's enough. That's fine. You had an exposure. 5 days later, you had a positive test or a diagnosis. That's enough to be off and running with a workers' comp claim. Now, what you're going to see, and I get emails from Sherry on this regularly, is that the employer is contesting the workers' compensation claim. And, you file your 30C like you're supposed to, you report the injury like you're supposed to, you go to occupational health like you're supposed to. Everybody knows you got hurt at work. People saw it. No way any reasonable person could contest that you got hurt at work. But guess what? People that work for insurance companies are not reasonable people. They're insurance people. And under the Workers' Compensation Act, an employer, or in this case, their workers' comp insurance carrier, they have 28 days to act on the claim. If they do nothing, then on the 29th day, they own the claim. They can't contest it after that. So what winds up happening is they contest almost every claim. And they do that to preserve their rights in the event they want to contest some aspect of the claim in the future. Typically, it's related to medical treatment. So you have a nurse or a healthcare worker, a tech, you're lifting a heavy patient, you hurt your back, you file a claim, you go to Occ Health, and and you're out of work for a while. They're going to file a Form 43, almost, without exception, because in the event that they don't, on day 30, you need a fusion. They're going to pay for it. They're not going to be able to object to the fusion. They said, well, wait a minute. How could she need a fusion? It's only been 30 days. Can't we have her checked out by somebody else? Maybe there's a more conservative method of treatment that might be better. We want a second opinion. They won't be able to do that unless they filed this Form 43. So, I think the intent of the legislature was to hopefully move workers' compensation cases along quickly. That's why they put the 28 days. But the effect of it has been that because they don't have much time to act, they wind up contesting it within the 28 days. So what do? Well, you continue doing what you're supposed to be doing. You get a Form 43. What that does is, for practical purposes, it allows you to continue get a treatment. However, you you're most likely going to have to process that treatment through your own insurance, because comp might be contesting a certain course of treatment. Okay. And that's okay. We more often than not do get it resolved, but if that happens, you get a Form 43, you go to the doctor, the doctor always asks on those intake forms, is this a work-related injury? You're going to say yes. They're going to say that the medical records people, the people that do the billing may say, oh, workers' comp is contesting treatment. You just tell them, yes, here's my form 43 and here's my insurance card. And you give them those two things together. It lets their billing department know, okay, this is a contested case. Here's the employee's group health insurance. We'll process it through there. If, a month or two later goes by and we wind up getting the case accepted, then, Anthem or Cigna or whoever your group health insurance carrier is, they're going to look to get reimbursed from comp, and you're going to be reimbursed for any out-of-pocket expenses you incurred as a result of having to go through your own insurance. But the point I want everybody to take away is that don't forego or don't delay medical treatment because your claim is being contested. Continue getting treated for the injury. You want to get back to work. You want to get well. And we know that, the earlier you start to treat an injury, the better the healing process is going to be. So you don't want a back injury to go untreated any longer than it needs to be. So don't let this Form 43 scare you out of getting treated. Okay, and then I just spoke about these first two bullet points. And the third thing is, speak to the union president about that. Let them know, let him or her know, hey, KERMA or PMA or whoever it is, they're contesting my comp claim. The union president can get that member in touch with us, and we can provide legal assistance through the workers' comp process. And that's at no cost to union members. Now, if we're getting nowhere with the adjuster, right? We reach out to the adjuster, say, what's this about? The adjuster says, oh yeah, we just kind of put a placeholder there, tell her to process it through comp and we'll pay. Okay, then that's fine. But if something else is happening and the adjuster is either being non-responsive or they're saying, no, we really are contesting this, then the next step is we request a hearing before the commission to try to get the matter resolved. We send out letters to the member asking them to sign releases so we can get the medical records. That unfortunately can take some time getting the records. More often than not, what we need is what's called the causation letter from the doctor saying, hey, it's my medical opinion that it's more likely than not that this person certainly did get hurt at work. Once we have that, then we're in good shape and we have a strong claim to move forward on. The workers' comp insurance carrier can and often does send you to their doctor to have you looked at to see if a second opinion would be any different. And if there's a difference between the doctor's opinions, again, that's not uncommon, that does happen. Then more often than not, we go back to the commission and the workers' compensation commissioner will pick a doctor and send the injured employee to that doctor for a review. Those exams typically go well for us. Again, it's not because of any fancy lawyering, it's because the member actually did get hurt at work and they need treatment. And so what we do is we put together all the medical records from the treater. We have the medical records from the second opinion, and we put a packet together and we present it to this tie-breaking doctor. Doctor reviews the file. The employee comes in for an exam. And more often than not, the commissioner's examination goes in the way of the employee. Excuse me. Ideally, what's supposed to happen in workers' comp is you get what's called a voluntary agreement. That's a win. It means that they own the injury. And once that voluntary agreement's approved, they can never contest it later that you got hurt at work. They own it for good, and that's what's supposed to happen. If an employee is fully and temporarily disabled from work, they start receiving their workers' compensation benefits. Those should happen ideally right away. I think it's 3 days after you've missed 3 days of work, you start getting workers' comp benefits. Now, there are a lot of shortcomings with workers' comp, a lot. There's a there's a false narrative out there that workers' comp is a windfall, that it's a way for people to get free money, and that someone who's out on workers' comp is somehow taking the employer to the bank. Nothing can be further from the truth. When an employee is out of work collecting workers' comp, they're getting 75% of their net pay while they're out. So they're not getting their full pay, but they're still have to pay 100% of their bills, but yet they're getting 75% of their pay. That hurts. It hurts a lot. So it's not a windfall. It's the opposite. The other thing that happens is, you may miss out on overtime. You may miss out on differentials. You may miss out on perhaps supplemental per diem work that you would have done while you're out on workers' comp. What I will say is that they take your 52-week average as of the date you got injured. So you get injured today, 12/27 at work. They do a 52-week look back. How much did you make each week on average over the previous 52 weeks? And then that becomes your workers' comp rate. It's 75% of that average, and that's what you make going forward. So, you're not able to go to workers' comp and say, well, I would have worked more overtime because it's the holidays and people take time off. I would have killed overtime in the coming month. It doesn't work that way. It's a 52-week look back. So if you had a big year the year before you got hurt, then your comp rate's going to be, better for the injured employee. But if you didn't work a lot of overtime, but you planned on it, you planned on working overtime prospectively, it's not going to work out well for you. While you're out collecting the workers' comp rate of pay, you continue treating for the injury, going to your doctor's appointments. You want to make sure you're compliant with the treatment. People often ask, can I go to my own doctor? The answer is yes, you can, but you should continue to go with the doctor that's provided for you through workers' comp, okay? At some point in time, a doctor is going to say, this employee, this patient has reached maximum medical improvement. She's healed as much as she's going to heal from this injury. And her shoulder is only 80% of what it was prior to the injury. Well, if the shoulder is now only 80% of what it was, that means that that employee has a 20% disability to the shoulder. That 20% disability to the shoulder equates to money. That's the only time, quite frankly, that you wind up getting paid extra through workers' comp, is through that disability rating. And there's this really odd system where different body parts are afforded more compensation than others. The back is a big one, the brain, the heart, those are big ones. Shoulder, knee, not so much. And it's every single body part is listed on in this schedule, and it equates to compensation. The other thing that can happen is while you're out is at some point in time, you're treating for the injury. Hopefully you're getting better and the doctor releases you to light duty. So you're not yet able to perform full duty. You can't lift patients. You can't bend, can't squat, those kinds of things, but you have a work capacity. Is what's supposed to happen there is if the employer, if the hospital has light duty available, they need to make it available to you, to the injured worker, if it's available. They don't have to create light duty if it doesn't exist, but if it exists, they have to afford an injured worker the right to fill light duty positions. If there is no light duty, then what can and does happen is they can require the injured worker to perform job searches, to look for work that is within their restrictions. So if they have a no lifting restriction for a period of time, you're going to be collecting workers' comp. They want you looking for work, even though you are expecting to come back to your regular job after 6, 8, 10 weeks. I'm coming back. Why do I have to look for work? If you want to continue to collect the workers' comp disability payments while you're out, that's 75%. If you want to keep collecting it, you have to submit those job searches, you turn them in, and you keep getting paid. So that's that. This is some of what I spoke to already. Once you reach the maximum medical improvement, you get rated on that body part. It equates to number of weeks, depending on which body part and the number you're given. Again, if you have a back injury, which is big, I think it's like 364 weeks. Again, that's if your back is 100% disabled. You get a 25% rating to your back, 364 weeks. You're over 74 weeks of pay. That's a lot. What will often happen is they'll send you to another doctor to see if that doctor would somehow come up with a different rating. And that can and does happen. If it's a really high rating, they may look for a second opinion. The other thing I would say, another big takeaway is anytime an injured worker gets a Form 36 from workers' comp, they need to contact us as soon as possible. That is informing the member that something is about to change regarding their workers' comp benefits. Either it's going to stop, it's going to be reduced, something like that. You only have 10 days to contest that. So you need to act quickly. So if an injured worker is out there collecting workers' comp or they're treating for their injury, and all of a sudden they get in the mail a Form 36, they need to get to the union right away, get to us, and we'll figure out what's going on and request a hearing if needed. They can't cut off a worker without issuing the Form 36. That's automatic. But once you get that 36, that's your notice that, again, something's about to change. Typically it's not favorable. So you want to get us involved soon. This is something, again, that I've been dealing with, Sherry's been dealing with a lot, and a lot of healthcare workers have been dealing with. It's really important to know your employer's policy as it pertains to injury leave and or light duty. Every hospital has one. When you're out on a work-related injury, more often than not, the employer is going to put you on FMLA. They can do that. There's nothing wrong with doing that. And they're going to run your workers' comp or injury leave with FMLA. So you're out, 12, 14, 16 weeks on FMLA. Once your FMLA runs out, your job protection can also expire at the expiration of your FMLA. They have to enforce this policy uniformly. Again, they can't pick and choose who they're going to let go at the end of the 16 weeks and who they're not. It has to be consistently, uniformly applied to everybody. We're seeing it a lot at Bacchus, but not just Bacchus. We're seeing it other places too, where you have someone who gets hurt at work, they're out for a period of time, and they do wind up losing their jobs after that job protection expires. Now, the employer continues to be responsible for the injury. They have to continue treating the injury. They have to pay that disability rating I talked about. Once you've reached maximum medical improvement, they pay that. They have to continue paying that 75% workers' comp rate while you're disabled from work, even though you've been let go by your employer. You're still not able to work because of your injury, so they keep paying that. But Sherry's seen it, I've seen it, I'm sure some of others of you have seen it, where people say, wait a minute, I got hurt at work, how can I lose my job? It happens. It happens too frequently. And again, once they put you on FMLA, that's your job protection. When that expires, the job protection expires, even though it's a work-related injury. So like I said, and what I would like to ask, Sherry and John, if we should probably start collecting all of those policies from every employer as they relate to injury leave, light duty. That way, if we get someone from, whether it's Danbury, Bacchus, L&M, whoever, and someone says, hey, I just got a notice that I'm being separated or my position is being posted, we have the database of all those policies and we can see, if in fact it's conforming with the policy, and if it's being applied uniformly. So it'd be good to kind of have a bank of those policies.
Ours is actually right in our contract.
Well, I'm glad you said that. To the extent that a policy is in a contract, a union could take the position that it's bargainable, right? And a union can seek to negotiate perhaps a longer duration for injury leave, in the contract, and say, look, let's keep these people employed for a longer period of time than just what FMLA requires. When someone is out on an injury, a work-related injury. These are people that have been working for a long period of time. They know the work site, they're trained, they're competent. These are the people we should be trying to keep. Shouldn't be pushing them out the door because they got hurt at work.
Yeah. Actually, every negotiations, we have it in our contract, the same as L&M. Connie just posted that 1 year. We have the 1 year of inactive duty to stay on, but every negotiations they come at us and try to bring us down to 6 months. But
Sure.
we always, so far, we've been able to stay that off. So
And every union that doesn't have that should try to get that. That's good to know. Okay. I'm about 4 minutes early. Any questions on anything I've gone over, or anything else for that matter?
actually, I do.
Yeah.
So the new Connecticut FMLA, is there some information you can give us on that and how that works with workman's comp and how that works? I didn't know what happens with the Connecticut FMLA with workers' comp, the new one.
So, yeah, all of you in the private sector, you have this benefit available to you after January 1. The Connecticut FMLA, it's paid leave. There is an offset, Sherry, if you're collecting workers' comp. You can't collect both at the same time.
You can't.
Now, cannot. However, I attended a presentation with the general counsel of the authority. What is likely going to happen, and it's just because of how slowly things move. If you have a member who gets hurt at work and their claim is contested and they're out of work and maybe they don't have accrued time, they go unpaid, they're going to apply for the Connecticut paid family leave, and they should. They need the income, right? So they can go ahead and apply for that. And I would encourage them to do that. Maybe 4 weeks go by and their claim gets accepted. Workers' comp is now going to pay them back the 4 weeks, right? They're going to get a check for, the 4 weeks that they weren't getting paid for. You're going to have an overpayment situation there. So, it's going to have to be reconciled either with the paid leave authority, most likely with them. You're going to have to pay them back from the workers' comp you got. But I think that's better than, asking a healthcare worker to go 4 weeks without being paid. It's not fraud. It's not as if you're looking to collect from two resources at the same time. You're not. Again, a person's claim has been contested, no fault of her own. She's unpaid. She's out sick. She's injured. She can't go to work. She's eligible for the Connecticut paid family leave. Just, we want to advise those people that, hey, look, if workers' comp catches you up and there's an overlap, you're going to have to reimburse the paid leave authority. You can't receive benefits from both at the same time.
And do we have that website that they apply for the FMLA, the Connecticut FMLA? Because I've not been able to, I don't have that website to give to people.
Oh, sure. I can put it in the chat.
Thanks.
Oops, sorry. So you'll, once you get to that site, it asks you to set up an account. Anyone can set up an account, and it's not a bad idea to set up an account, whether or not you need it now or whether or not you think you might ever need it. You can go ahead and set up an account, not apply for any benefits, but your account is set up. That way, you know, the time comes you need the benefit, your account's there, and you can submit the application to get the benefits. And those are available, I think it's 12 or 14 weeks. There's an additional 2 weeks if there's complications due to pregnancy or delivery. And there's statutory caps to those benefits. I think for the first period of time, I think the statutory cap is $780 a week. And it goes up from there each year. But you know, it's a progressive benefit. It's something that Connecticut can be proud of. Good question, Connie. Can someone collect from the Connecticut leave and their short-term disability? That's going to be governed by your short-term disability policy. You know, that's an insurance policy, whether it's AFLAC or through your employer. You may be able to collect from both. I don't believe the Connecticut Paid Leave Authority would have a problem with you collecting on an insurance policy, but you may want to check with the insurance policy to see if there's an offset. If you're collecting some other benefit, there may be. So you want to check the insurance policy. One other thing, just because we're still kind of neck deep in the pandemic and what you guys are all going through on the workers' comp piece on COVID, if any of you or your colleagues or your members do contract COVID and you have, whether it's a known exposure or a suspected exposure, file the Form 30C. File the Form 30C, and when I was going over that, you know, just reference when you think you may have been exposed. Again, you don't have to identify a certain patient that was a COVID positive patient. You could just say that, you know, you were at work in this unit that had COVID patients on this date. And then, you know, whatever it was, 2, 3, 5, 7 days later, you tested positive, and get that filed. You know, you guys know the governor had executive orders that covered healthcare workers and first responders for a period of time. That period of time has expired. That doesn't mean, though, that we still can't prove that you got COVID at work. And workers' compensation commissioners are pretty empathetic to you guys. They know how hard you're working. They know the danger you're putting yourself in. No one should ever feel as though they're doing something wrong by filing a workers' compensation claim, or they're somehow not, not as dedicated of an employee because I filed a workers' compensation claim. Don't ever think that, or don't allow your colleagues to think that. That's what it's there for. It's insurance. We all pay for it anyways. You get hurt at work, you get sick at work, you need to file a claim. Any other questions?
Yeah, Eric, quick question. I have a couple of members that are long haulers. We filed workers' comp, we filed the 30C on their behalf. One of them is getting medical benefits paid. Another member is suffering really long-term health effects from her COVID exposure. Does that same workers' comp claim follow the life of the employee?
Yes, it does. You don't have to file a new claim. Every time symptoms may resurface, you do not have to file a new claim. It's the same original claim.
Thank
you. Kathleen asked, I think I mentioned this during the presentation, what religion objects to the vaccine mandate? I'll tell you that no hearing officer is going to ask that question. They're just not going to ask it. If a member tells their employer that they have a sincerely held religious belief that objects to a vaccine, an employer can ask for some type of corroboration of that. They can. It's been my experience, most don't ask for that. But instead, what they wind up doing is going through the process, and at the end of the process, they say, no, we can't accommodate you. They don't, an employer really isn't interested in picking and choosing which religions satisfy a request for an accommodation. You can imagine why they wouldn't want to go down that road. It's really an easier road for the employer just to go through the process and tell them, we went through the process, we can't accommodate you. But I guess to answer Kathleen's question, if it's a sincerely held belief that, you know, perhaps someone can put their name to or put on a letterhead that this belief, this sincerely held religious belief objects to the vaccine, that's probably going to be enough.
Yeah, I just wanted to mention that I'm Danbury, Unit 47. There were a lot of nurses that did object to the mandate because of religious reasons, and they were all turned down. So that's why I had that question, was they probably went through the process and then eliminated nobody got anything for religious. If they did have a religious objection, it was turned down.
Yep, that's the safer bet, quite frankly, for the employer.
Yeah,
My
understanding from some of the conversations I had with Janice was that they were not questioning the sincerely held belief. They were just saying that they didn't have a reasonable accommodation.
Yep.
That way they don't get caught in the discrimination thing.
Exactly. Well, if there's no other questions, I hope you guys are having a good holiday season, and hope you're staying as safe as you can. And thanks for what you guys are doing. It's amazing, really, what you guys are all doing. It's incredible.
Thanks, Eric. And if people come up with questions about this or any other legal things, you can always shoot them through your leadership, or through Sherry, or through I, and we can have Eric or one of his colleagues address the questions.
Absolutely. Yep.
All right, guys. Thank you all for hopping on this evening. I discovered, as did John Brady, that the link I have for the survey is broken. So I will have Anna email a corrected link out to everybody on the 4th when she returns to the office. In the meantime, if you need a professional development certification of completion, you can also email Anna, and I just sent that directly to John, so he already knows Anna's email address. Hey, Dayquil, it's a hell of a drug. You can email amowery@aftct.org. I put that in the chat box for you. She'll send an email out on the 4th when she gets back. I hope you will join us for future upcoming professional development opportunities that we have going on for our members. Those webinars can be found on the calendar at our website, www.aftct.org. And thank you all for what you do. And I hope you have a good evening and a happy new year.
Thanks, but before we go, there's one more question in the chat that popped up about boosters.
Right. Can we be forced to have boosters every couple months? I'm hearing it wanes pretty quickly. The booster. Yeah.
You blame in the box. That's good.
I think
that for you.
the answer would probably be the same as it would be for the mandatory vaccination policy. If there's a mandated vaccination policy, they could apply the booster to that policy. So I think it'd be answered the same way as a mandatory vaccination. Similar to the flu shot. A lot of healthcare workers are required to get the flu shot every year. if it's comes to the point where the COVID vaccine is a 6-month booster, it's possible that there could be a vaccination policy that requires a booster every 6 months, if that's what is ultimately determined as necessary.
All right,
All
well,
right,
I
thanks
did my
again,
spiel,
everybody.
so
All right,
we're good.
all right.
I'm gonna
Good
go
night,
take some
everybody.
NyQuil now.
Be safe, everyone.